Now, for instance, I'm sure you wouldn't also deny the fact that between the time that Navtej was delivered and today, our society has found much greater acceptance, say, of same-sex relationships. For the last 5 years that we have seen it unfold, there's
Definitely.
been, and that's very positive because there you find that there is a greater acceptance in our universities. And by the way, our universities don't consist of only urban kids; they all come
Yes,
from the
yes, of course, from
smaller
all over the country.
smaller areas. Yes,
Yes.
but there is this acceptance which is evolving. So, in this evolving consensus, the court is also playing a dialogical role to
Yes.
create that consensus and move towards a more equal future.
My lord,
While being conscious of our own
yes,
limitations, which we
yes, my
can't
lord, I
deny in
follow.
the legislative
I
arena.
follow. My lords, the only request I would make is that the question may be left open to be adjudicated.
Obviously, we're not going to reject what we don't.
Yes,
We can always.
Our model, where your lordship in constitutional adjudication have equalized and brought the left out category into the existing category, my lord. Not just the executive instruction case in Nakara. In All India Sikkim old settlers recently, following Vishnudas, Handimal, ITO Lawrence and other cases, where, my lord, some people were left out of certain benefits. Your lordship said striking down will deny everybody the benefit. I will now equalize them, my lord. A good body of case law. The other is the Fowry model, my lord, of South Africa, where they said the common law understanding and the statutory understanding is unconstitutional. We strike it down, but we suspend the declaration. No doubt in South Africa, there's an express provision in 172 permitting that. But, my lord, that was how they equalized it. But your lordships have gone one step further. Read in, my lord. But your lordships have read it in, my lord. Nakara was an executive instruction case, but I've got statutory provisions where your lordships have equalized the left out category. The last of which is, my lord, the judgment 3 months back in All India Sikkim old settlers, where the Indian origin settlers who did not give up citizenship, my lord, of India, were left out of the Sikkim register. And our Income Tax Act, my lord, confined benefits to people who are in the Sikkim register. So our argument was, we never gave up the citizenship pre-accession. Lordship said, yes, we will now equalize you.
Different ways where reliefs are molded.
Reliefs are molded.
Prabhakar.
The rent control matter.
No. During an interregnum period, the retirement age had been decreased from 58 to 55.
Oh, yes.
This court, by Constitution bench, upheld it. But later, due to public pressure, it was restored.
Yes.
In between, people had retired.
Nagaraj.
And what was restored was with retrospective effect.
Yes.
The court said not giving retrospective effect is resulting in discrimination and gave it retrospective. One of those rare instances where relief is molded in a particular manner where legislation intends a certain consequence.
Consequence, my lord.
So,
Now,
Vishwanathan,
my lord, in
will it not
Sikkim,
involve
the classic case where your lordship equalized it. So, my lord, that need not, my lord, deter or, my lord, hold back the court at all. If your lordships find that confining the status of marriage to heterosexual couples is wrong, and this is, my lord, a status which requires recognition by the state, denied to a set of people who otherwise have fundamental rights. Your lordships find that, your lordships have already, according to me, now when your lordship said equal platform, words are, my lord, very specifically used. Your lordships will, my lord, say that they have to be recognized and brought into the sphere. It is for Parliament to tailor law to bring it in accord with fundamental rights, my lord. It can never be that, my lord, you await for them to legislate. That will be, my lord, submitting to, my lord, popular will, which, my lord, is completely contrary, anathema to fundamental rights. The whole idea of fundamental rights is to, my lord, to keep it out of the reign of majority.
Now that we have understood, broadly, we've understood the canvas of the matter, then we can really, at least at this stage, we are not ruling it out for the future, we can steer clear of personal law in that case. So if we steer clear of personal law, then perhaps we make the first. I mean that is one possible option as you opened it
As
up.
far as two of us are concerned, we are not leading. There may be other people.
My lord, there are concerns about the Hindu marriage.
Because it may not be necessary for the court then to get into more vexed issues pertaining to personal law.
It's codified.
Yes, my lords, Hindu marriage, the
It's
Hindu Marriage
codified.
Act.
So perhaps you can all address us on this aspect. That's why when we began, we as
Can I take 2 minutes?
Just a minute.
5 minutes.
Just a minute.
The possibility the states must be heard. It's a constitutional issue.
Dr. Goswami?
My lords, thank you. My lord, the Chief Justice may recognize, my lords, that the Hindu Marriage Act is not an issue necessarily of personal law. It is statutory law. And we will demonstrate that. The terms of the Constitution, the reform of the Hindu Marriage Act has always been in the context of statutory law. So, my lords, to that extent and that extent only, in the context of statutory law and making statutory law workable, because my lords will know, my lords, that the origin of the Hindu Marriage Act, the Hindu Code, did something that was not permitted in sacramental Hindu law, which is intercaste marriage, Sagotra marriage, divorce,
Inheritance to.
Maybe Dr.
inheritance.
Goswami, but there's also with Dr. Goswami, there may be some amount of sage wisdom in also going about our interpretative task in incremental manners, because otherwise, do we then confine ourselves only to the Hindu Marriage Act? Then what about the Parsi Marriage Act? What about the Muslim law? What about the Jews? What about the Buddhists? A lot of other communities. Therefore, perhaps one option for the court, because the constitution itself and the law is itself evolving. So, and the court has to be mindful of the fact that we are doing by process of interpretation what you're calling upon us to do. So it may be, there may be some element
Two
of
minutes for the after?
some element of
Lord,
judicial
if I may-
discretion and perhaps going incrementally,
Yes.
covering a canvas for the present, which would substantially then, assuming that even there you are right, because you have to hear the other side, confine yourself to this
Lord.
incremental canvas and then allow society to evolve, allow Parliament's perceptions to evolve over a period of time, because Parliament is also responding to the evolution of society over a period of
One
time.
is the canvas after Ms. Goswami is finished. I want just 3 or 4 minutes. We finished?
Yeah, go ahead.
But it's only 3 or 4 because learned friend is given, my learned friend is given.
Because we can't deny the fact.
On canvas.
We can't deny the fact that there is undoubtedly the legislative element also involved, which is why we are saying states, the parliament, what the
My
solicitor said.
respectful submission.
Having regard to that, we
Hello?
need to balance out various facets. So this might be perhaps one way forward.
That's the only thing I'll say to this. Is,
So we don't have to decide everything to decide something in this case.
no, my lords, I follow. I follow. The only thing
There are,
I'll say to,
Goswami,
yes, my lords.
one is the channel pointed out by Mr. Rodgi in a restrictive sense that only construe the Special Marriage Act. If it founds favor with us, it will give us status of marriage. If it not, he rightly said you are out. Therefore, whether other issues at all arise or don't arise, will depend on how we interpret this aspect. Other
Lord,
issues
if I
may
may-
survive for another day, or may not survive for the time being for another day, depending on what view we take on this core issue. And in the wisdom, as the Chief Justice said, sometimes incremental changes in issues of social and society ramifications are possibly a better course. There is a time for everything. There is time for some things to come. Therefore, what was being suggested was, can we, for the time being, confine it only to this limited issue? Don't step into, let me complete. Don't step into personal law issues under different religious norms. Don't get into any of those issues, but only say that, can the Special Marriage Act be interpreted in a manner by reading into it a gender neutral situation, period.
Can I say?
Lord,
And perhaps
that's-
you can then
maybe
help us,
the
you can assist
question
us,
is
you can
left
assist
open.
us, and we'll ask the solicitor also to assist us on how we can sort of develop the notion of a civil union,
Yes.
which really finds recognition in our statute, namely the Special Marriage Act. See, because now, for instance, I'm sure you wouldn't also deny the fact that between the time that Navtej was delivered and today, our society has found much greater acceptance, say, of same-sex relationships. For the last 5 years that we have seen it unfold, There's
Definitely.
been, and that's very positive because there you find that there is a greater acceptance in our universities. And by the way, our universities don't consist of only urban kids; they all come
Yes,
from the
yes, of course,
smaller
all over the country.
smaller areas. Yes,
Yes.
but there is this acceptance which is evolving. So in this evolving consensus, the court is also playing a dialogical role to
Yes.
create that consensus and move towards a more equal future.
My lord,
It's for
While
the,
being conscious of our own limitations, which we
Yes, my
can't
lord.
deny
I
in
follow.
the legislative
Well,
arena.
I follow that.
I-
My lords, the only request I would make is that the question may be left open to be adjudicated. at a
Obviously,
future
we're not
time.
going to reject
Obviously.
what we don't.
Yes,
We
ma'am.
can always
But we-
confine our
Yes.
canvas and then not reject.
Yes.
Obviously not.
Yes. And my
That is not
second
necessary for the court to do at all.
point is simply this, that the second point is simply this, that marriage is not only, as if that were not
But
enough.
leave broader and broader issues for an evolving future.
Yes, but marriage is not only a question of dignity, as if that were not enough. It is also a bouquet of rights that LGBTQ people are being denied post Johar. Right? Those rights are simple things: bank account, life insurance, medical insurance. I, for instance, frankly,
Rental accommodation.
I cannot buy SCBA medical insurance.
citizenship.
I am a member of the SCBA bar. I cannot buy my family medical insurance from the SCBA. So this is the reality of how rights are exercised. Rights are exercised when you are able to protect your relationships. One facet of that right is a constitutional value of dignity, equality, fraternity. The other facet of that rights is the day-to-day business of life. And the day-to-day business of life is all of these things. Now, when we look at law in India, and all common law is premised like this, that most rights flow from this notion of blood relationship, i.e., either being born into the family or being married. That is the problem, my lords. And so, therefore, short of full marriage, whether my lords find that under the Special Marriage Act or be that as it may, short of full marriage, it will mean, if it's short of that, it will mean that subsequently, not just Mr. Rodgi, Mr. Kripal, me, we will keep coming back to court to have to litigate individual issues of discrimination. I am not able to nominate my partner for life insurance. Now, these are not theoretical issues. This is our life. Right? So therefore we say marriage, because that is the notion, not only for society, but that is the notion that the legal framework, which is premised on common law, understand and takes within its fold. So not, therefore, my lords, respectfully, therefore the problem is that anything short of that, if it is a civil union, so this correspondence will now start, my lord, with insurance company, with banks, with hospitals, with wills, with estate duties, with anything that is prerequisite to being able to live a life outside the home, including buying that home.
Well, it's,
So the
for
status,
example,
and so there are
things.
folds here.
Mr. Rodgi, taking a cue from what she says,
Yeah.
see, even in Puttaswamy, when we laid down the right of privacy,
Yeah.
we were conscious that it had many nuances. We said we can't beforehand take all nuances into account and rule on this thing. As it evolves, things will evolve. That's the basis of the.
These are absolute day-to-day issues.
So,
Take the Income Tax Act. The two partners can't give a gift. Gift is free of tax,
Rodgi,
but provided you are married.
Well, there are two
if you
kinds of.
succeed, I'm saying if you succeed on the fundamental issue
Yes,
that it can be
Of
read
marriage.
into,
things will work out.
many nuances will start, may take time to work out, it may require more visits to the court, one can't say. But it is very difficult to say that we work out all possible nuances now, even the nuances which you think exist at the moment, to be taken as a bundle of things and dealt with.
So,
Therefore, the suggestion which was following was, let us, if we confine it to this fundamental issue under a particular act, that's it.
Yes, my
We
lord.
don't touch personal
I-
laws,
I-
we don't touch anything else. We don't get into anything else.
Whereas on the canvas,
on-
whereas I want to say this first.
Yeah.
On the canvas, just one second, but on canvas, There are two words here. Of course, on the confinement, it is with great respect, the better profitable way of doing it. There are very valuable arguments by the Hindu Marriage Act batch or even by other personal laws. Both of us, in the two lead matters are not arguing that. We are only in SMA. So, a way to start would be to limit it there. I entirely bow down to what is falling from my lords. But, on the canvas, just 3 or 4 minutes, there are two crucial words here, marriage and persons. Same sex is a slight misnomer. The correct word is person, not same sex. I'll just take 3 or 4 minutes first. Marriage, largely, my learned friend is covered. Well, there is two categories of consequences. These are consequential issues she is raising. One is the minor or major secular consequences of marriage. Your lordship is not in this matter. In the event that your lordship holds marriage to be this way or that way, not creating an empty shell called the word marriage. It has to have some consequential benefits. Marriage, in any case, now you can have a live-in. You need not even call it marriage. It is because of the consequential benefits. So your lordships may need, this is entirely a lordship discretion. I understand it's a great advance in law if your lordship even were to interpret same person marriage as a marriage. I'm not at all diluting or reducing that. But your lordships, according to me, even in this more limited canvas, must consider traveling a little ahead. One category is what my learned friend has said. These are secular incidents of daily life. They involve nothing beyond that. And your lordships can have a reasonable listing. Now, there are larger issues which your lordship will explicitly keep open. I would say that even those can be covered by marriage, but possibly, we are too early to start doing that. There is succession law, certain aspects. There is adoption law, certain aspects. There is certain other things. We are not at all, giving it up or lessening it. But your lordships in this, the crucial word which tells the Chief Justice is incremental. I always believe that, your lordships in such matters is like a rubber band. Your lordship expands incrementally slightly. You stretch the rubber band too much, your lordship is pushing pressure that the rubber band will break, because that slowly movements is on the societal view of the rubber band. Now, adoption, according to me, is crucial. Is crucial. There may be some non-adoption issues which your lordship may not consider crucial. I'm not able to, in fact, itemize. But your lordship will guard against holding on the left hand, in the event your lordship so holds, that marriage of same persons is valid, and on the right hand, make it an empty shell. That is point one. Point two of the canvas is even more important. The point arises from not having to come to your lordships every day. That's why I said the word is actually more appropriate. I've looked into this, some literature, same person. Now, your lordship has got, one is heterosexual marriage. Lordship will call it this side. One is man-man or woman-woman, which we call homosexual or lesbian on the other side. Now, there are two actually parameters of differentiation. One is sex-based, which must include between the man and woman sex. There is also a whole range of combination of persons with special biological features. It's not only man, it's not only woman. The second category is gender. That is the masculine, feminine. So a male body can be imbued and overshadowed by completely female psychological instincts, and vice versa. So therefore, once your lordship holds today, assume, as a matter of argument, that your lordship were to hold that same sex marriage is valid. Same sex in the sense of man-man, woman-woman. It is not intended that persons who are in this, what is known as the whole range of shades, the complete spectrum. What your lordship we tend to say LGBTQ. I looked it up. It is L, lesbian, G, gay, B, bisexual, T, transgender, Q, queer, I, intersex. And then your lordship says A, asexual. And then your lordship says plus plus. The actual correct thing is, so this plus plus is a whole shade, a spectrum of different hues and colors. Now, clearly, if your lordship were to hold same person marriage, your lordship doesn't mean to limit it to same sex marriage. In the event your lordship were to hold, so that your lordship doesn't have a tomorrow a new person coming here and saying this. So the correct formulation would be to consult. two consenting adults. I'm only giving a summary. Two consenting adults along the bodily, gender and sex spectrum. Either you define by gender or by sex spectrum. This is the other facet. Now, all of this can be profitably started with SMA, because your lordship is making a start. Were your lordship to leave the rest of it explicitly open, or your lordship may have a deferment and have it considered separately, it's entire your lordship discretion. They have also valuable points. Are not only the Hindu Marriage Act category, other people also. Hindu Marriage Act category is there also. Secondly, let us be very clear. I heard with some alarm my learned friend's opening intervention. Nobody is arguing at the moment. Nobody, I will not say, at least the two of us, or the three of us, are not arguing personal laws at all.
We are not.
Number three, we are, what is the meaning of this repeated thing about state intervention? Your lordship, for the first batch, is interpreting this way or that way, whether SMA, and our arguments, that is my arguments, are in two parts. One is these fourfold parameters of discrimination, which is the most important, 15, 14. Second is freedom of expression. The very interesting facet of freedom of expression, the lordship has said, is symbolic in a community sense, not only individual. Third is dignity, 21 and other things. Fourth is how to remedy it. And the second part of the submissions is the entire notice objections regime of the SMA. That part would have to be held unconstitutional. The first part is interpretive. If your lordship is with us on that, the second part would have to be unconstitutional.
The notice issue is even in a heterosexual marriage, because you are saying that even in a heterosexual marriage, the fact that you have to give a notice and have people object to whether there should be a marriage or not is unconstitutional.
The funny part is, and this is just an aside, that the object, howsoever noble, of having this section 5 to 10 regime is being proved by statistics on the ground to have the exact opposite effect. Exact opposite. Your lordship invites opprobrium, oppression, physicality, violence, elimination, extermination. And I'm asking myself one question. Your lordship has conditions of marriage in all, even Parsis, Christians, Hindu Marriage Act, other acts. Conditions of marriage are there, but something or the other is there. If you give an affidavit saying I'm satisfying the conditions, and your lordship subsequently files the affidavit to be false, or any spouse finds it, or even a third party finds it can be struck down. It's void or voidable, it's struck down all the time. You don't need to have a notice period in advance after the conditions. This is peculiar to only the SMA. Your lordship is not allowing those conditions to be violated by the non-following of objections. It's a absurd situation. Now, that being the situation. Yes. Sorry, I can't. This intervention about state objections.
No, I'm saying therefore, you say you don't want to touch personal laws, correct? And we've also put to you, don't touch personal law.
I have not touched.
Then the argument is in a very limited compass or
Focused.
That confined is, can we in the Special Marriage Act read a person instead of the definition of a woman or man?
That's all.
That's all.
And leave everything else for some
Better day.
good time in the future.
That's
My lord, just one aspect.
and no state intervention inhibits your lordship.
May I then proceed?
My lord, just one aspect.
I think then
One
we can,
minute.
I think we'll now get back to Mr. Rohatgi. So we'll get back to Mr. Rohatgi.
My lord,
Now
my lord,
clarified. 1 second, just 1 second, 1 second. We have, I think all of us on the bench have now clarified the area, or you may call it the limited area, or the area that we are going to explore in this case. Let's hear Mr. Rohatgi on that, because I
my
think
lord,
now,
my lord, just
On the ambit, my lords, briefly,
My
just
lord,
on the ambit, if I may be permitted.
this,
My lords,
which
we have
is
challenged
true.
in addition the other two secular legislations, and many of us have, which are the Foreign Marriage Act and the Citizenship Act.
My lord,
My
that's,
lords, with regard to the Citizenship Act, the word spouse has been used in 2015, subsequent to all of these other legislations. So if the doctrine of casus omissus is applied, all that is required is very, very low-hanging fruit, my lords. All that is required is to be said that spouse means spouse.
See, one thing is either we confine it to this, the debate will be limited and we'll know whether we agree with you or not today.
my-
If we don't agree with you, nothing survives.
so,
All those issues, all other issues don't survive.
When you're
If we, one
My,
second,
my lords,
if we suppose we agree with you on this
Yes, my
limited issue, then in what ramification, what nuance the other thing survives will be a second innings,
my lord,
second, third, what
my
time.
lord, the Foreign Marriage Act is actually a secular act, which is really a takeoff from the Special Marriage Act. So that would have to be included in this
You
canvas.
can add supplement.
It is only
Let's do this. Let's do this
one
now.
and the same.
We'll now start with Mr. Rodgi's submission, so that we can now look at it. We can now look at it with a sense of a constitution bench hearing.
So that it's there. My lords can tell us whether we should then address. My lords, as Dr. Singhvi has already addressed, the petitioners before you are not necessarily same-sex couples. In fact, in my petition, the Rituparna Bora petition, there are petitioners who have anonymized themselves because they are coming from oppressed castes and communities. They are trans persons, irrespective of sexual orientation or gender identity. The relationships are taken place. So perhaps same-sex will not include them in that description. I will
Yeah, therefore the emphasis is on personhood,
Person, same
on
person.
person.
aspect, we are also chosen family.
Consulting,
We also
adult-
say
Consulting
typical family. Can they be, like there is a live-in, can they be a chosen family, particularly when my natal family is hostile? These petitioners have faced hostility and violence from the natal family.
That's the perspective we wish to give.
A chosen family, both to take care of them and the accruing rights.
All right. Now, Mr. Rodgi, you can open now.
Can I?
My lord, as far as I'm
Mr. Rodgi, now tell us about what's the time estimate for you?
my lord, all my time has been hijacked by people on my side.
No, but now we sort of, now the constitution bench begins as a
confine.
Can
constitution.
I-
Now confine yourself to this.
Only this.
My lord, your lordship.
Yes, only this.
My lord, your lordships, while fixing the remit of the matter also, your lordship said that we would hear the side. My lord, would your lordships like to consider hearing us? Your lordships have fixed the remits.
All right. Yes, certainly,
Okay.
Mr. Yes, Mr.
Well, I will-
Mr. Mehta. Certainly. Yes, Solicitor.